Sir,
Very good afternoon. Very good afternoon.
sir, sir, am I audible, sir?
Yeah, you are. You are.
Sir, we will start in 5 minutes, sir, because it's post-lunch session.
We'll wait for 5 minutes.
Yes, sir.
Sure. I'll be
Yes, sir.
online.
Yes,
I'll
sir, please.
switch off my camera and video, audio. So
Yes, sir.
whenever you are ready, just let me know. I'll join.
Okay, sir. Sure, sir. Thank you, sir.
Krishna, am I audible?
Yes, sir. You are audible, sir.
I think you can start because you have already kept the recording on, or else it will be the recording is going on. No?
Yes, sir. Okay, sir. Okay. Good afternoon, everyone. My name is Krishna Shekhar Sharma. I'm a research scholar from Department of Law. Namaste, sir. We have Professor GB Reddy, sir, with us. He will be talking on copyrights and creative works, protecting artistic and academic innovations. Sir, on behalf of Department of Law, I welcome you to this FDP, 7-day FDP on IPR. Sir, welcome you, sir. Yes. Now I request Ms. Niranjana PC, LLM first year student, Department of Law, to introduce our honorable resource person. Niranjana.
Yes, sir. Good afternoon, one and all. It's my privilege to introduce Professor G.B. Reddy, sir, Senior Professor of Law, University College of Law, Osmania University, Hyderabad. Dr. G.B. Reddy, sir, is a lawyer turned academician, studied graduation B and LLM in Constitutional Law at Osmania University and PG Diploma in University of Hyderabad.
Niranjana, your voice is not audible.
Constitutional in and
Sir, I think
not audible,
now
sir.
it is better. Yeah, it is better now, Niranjana.
Hello.
Hello.
Now it's audible.
Yes. Yes, Niranjana, you are
Hello?
audible.
Okay, his area of specialization in constitutional law He specialized in the area of intellectual property as an independent.
I think it's okay. No issue because I think there is some connectivity issue. So we'll skip that. When No, it's absolutely
Sir,
no
we are
issue.
sorry,
We can start.
we
So
are experiencing
yeah, I understand.
great network issue in the
Yeah,
campus.
thank you, ma'am. No issue. So it is deemed to be introduced. No issue. Thank you. Shall I
Yes,
start?
sir.
Ah.
Yes, sir. Before you start, I have two announcements to the participants. Dear participants, please don't put any messages, good morning, good afternoon, and all introducing yourself in the chat box. Okay, we will be disabling the chat box. Before the question and answer session, we will again turn it on. And also make sure your mic and your videos are mic is muted, and video, if it is very good, then only turn on. Please don't show your ceiling and all. Thank you. Sir, you can take
So,
over the
Yes,
session,
yes.
sir.
Yeah.
Krishna,
Thank you.
sir. Just one more thing.
Sir,
It's a lengthy session, so sir, if you have the liberty to take a break in between, sir, 10 to 15 minutes, sir.
uh, sorry.
Okay. So you can tell me when the break will
It's
be.
up
You
to
can
you.
announce then. Okay.
It's up to you,
So
sir.
maybe we'll okay 3:15. We will have
Okay,
a
sir.
break at 3:10. 3:10. 3:10.
Okay, sir. Yes, sir.
Okay.
Thank you, sir.
Right. Thank you. Uh, Very good afternoon to all the dear colleagues from different universities and the colleagues from the School of Law, Central University of Karnataka, Gulbarga. So Dr. Jayanta Barua and other friends. I'm very happy to be with you this afternoon. And the topic assigned to me is, in fact, the copyright protection in case of the literary, artistic, and other creative works. You know very well that if at all there are few intellectual property rights which are closely related to academic world, they are the copyright and patents. The rest, no doubt, may be relevant, but they are not as relevant as these two are concerned. And another speciality of copyright is that it's related to every discipline, every faculty, every department, whereas patents probably are mostly confined to, let's say, science, technology, engineering, mathematics, so on and so forth. So, in that sense, copyright assumes great importance. And as the creators of artistic works are, more importantly, the literary works, and as performers in the technical sense in our day-to-day teaching, I think the teachers have to learn, unlearn, and relearn many things in respect of the copyright protection, not only because we need it, because our university wants that original works are created, and the university grants commission says that the academic honesty has to be maintained. So these are some of the most important aspects. So therefore, let's try to, in fact, understand the nuances of copyright protection during the next, let us say, 2.5 hours or so. I'll make a small presentation. Our discussion need not be confined to those presentations, but nowadays, I think this is the generation of PPTs and PDFs. We can't get away from those. It doesn't matter. Uh, I'm happy with chalk and talk, but you will get bored by looking at my face all along. So let me make a small presentation, please. Just a second. Just a second. Can you see it on the screen, please?
No, sir.
No. Okay, just a second. It's always a problem. Okay, it's again opening. Let me see. Let me see. Anyway, before it opens, let's also try to understand that there are number of misconceptions about the concept of copyright, and as to how in fact many people think that copyright means right to copy, right? And what exactly is copyright, I will tell you a little while later. Before that, I would like to in fact draw your attention to a few interesting options. Just a second, I'll make one sincere attempt. Present now. PPT on copyright protection block. Okay. Yeah. Now you can see it?
Yes, sir.
Yes.
Okay, fine. This one, no? Okay. Right. Draw your attention to a few, in fact, important aspects relating to, the copyright protection. More importantly, a statement which was made long time back. I keep on using it. I don't know whether there is copyright in this statement or not. I don't think there is any. Way back in 1997, I happened to, stumble upon a very good article published in Harvard Business Review. That was in September 1997 issue. And there, one of the authors was trying to, in fact, suggest a new legal regime of intellectual property rights. And in the course of his article, he made this wonderful statement saying that for more than a century, the world's wealthiest man has been associated with oil, but now he is a knowledge worker. That was in 97. He was referring to Bill Gates. And Bill Gates, I think, still continues to be one of the top 10, in fact, wealthiest men in the world, not because of oil, as in the case of maybe Sultan of Brunei at one point of time, or John D. Rockefeller, but because of intellectual property, because knowledge has become wealth. With regard to copyright, it is very often said that what is worth copying is worth protecting, because we are living in an age where copying becomes an imperative at times, and it has become a culture as well. But whatever can be copied also needs effective protection. And I mentioned about the popular misconception that copyright, in fact, my young students also respond to me whenever I ask them to define copyright. They say, sir, right to copy. Of course, their direction is in the examination hall, not here. Right to copy. I say, yes, you are right, but not in the examination hall. Right to copy your own works, right? So it's popularly said that copyright includes the right to steal ideas, right to steal facts, the style, the content, the expression that cannot be copied. And Mark Twain, very famous, for his wonderful quotations, once said, only one thing is impossible for God: to find any sense in any copyright law on the planet. because many people think that there is no need of copyright law. And some people say that copyright has divine origins. In fact, the Western copyright or intellectual property experts very often refer to one of the 10 commandments, that is, thou shalt not steal, as the basis for the copyright protection. But the fact remains that in modern times, copyright has become an integral part of the knowledge industries, and there are any number of industries which are dependent on the effective copyright protection. At one point of time, it was mentioned that copyright was the concern of lonely, starving authors. Today, you can't say that. You can't say that it's only the lonely, starving authors who are concerned with the copyright protection. It is the entertainment industry, it is the publishing industry, it is the academic industry, and it is the music industry, cinema industry, publishing industry, you name it, there is no industry which is not related to copyright. So this is one important factor, please. Now, whether it is intellectual property in general or copyright in particular, we can always say that it is the process of revolutionizing the way we are living in the 21st century. And we are witnessing the impact of knowledge revolution. Your Alexa is an example, Gemini is an example, Siri is an example, GPT chatbot is an example, and the entire process manifests just one thing. Knowledge has become a central point. Everything revolves around the knowledge. Of course, now human beings are talking more about artificial intelligence than the natural intelligence or native intelligence. But if you look at the sunrise of knowledge from 17th century to 21st, every century was dominated by one particular, in fact, theme. If scientific revolution was witnessed in 17th century, political revolution in the 18th century, industrial revolution in the 19th century, IPRs came into prominence in this. Then information revolution during the last century, and here we are in the 21st century, it is the knowledge revolution. So knowledge has become property. Knowledge is wealth. Knowledge is not only power, but property. And that can be seen in the form of, any of these intellectual property rights when they are commercially exploited. What is intellectual property must have been explained in greater detail in the morning session. I will not go deeper into this, but for my satisfaction, just I'll run through. We are talking about intangible property, the creation of human mind. You are talking about a property which is in the form of rights, and these rights are arising out of the intellectual activity in different fields, maybe science, engineering, technology, literature, art, so on and so forth. And when we talk about intellectual property rights, they are given different names depending on the nature: patents, trademarks, copyright, design, so on and so forth. And intellectual property is not intrinsically related only to technology. There are any number of intellectual property rights which are not related to technology, but still they fall within the meaning of intellectual property. And the uniqueness of intellectual property is that they are transnational in character. You can't keep them in a safe deposit locker. The original will remain original, but there can be any number of other copies and originals without affecting the originality of the first one. It can be multiplied because intellectual property is in the form of information. It is the information which is sought to be protected by conferring these rights. Expressive information is protected by copyright. Technological information is protected by patent. Symbolic information is protected by trademarks. Aesthetic information is protected by designs. Geographical information is protected by geographical indications or GI tags. So ultimately it is the information, and information has no shape, no form. You can't keep it in a safe deposit locker. Therefore, it is accessible anywhere and everywhere with a little effort. That is the meaning of transnational in character. For example, if anything is posted on World Wide Web, even if it is a copyrighted version, it can be accessed anywhere in the world. In Timbuktu also, within no time. There is no territorial protection here. It's even if we have copyright reserved or registered, that may not be sufficient to protect the same if it is accessed in other part of the world. And the last point is that we are talking about intellectual property rights, which are limited monopoly rights in general. Because if it is movable or immovable property, which is a traditional kind of property, there is no shelf life for it. One can enjoy such property for any duration of time, right? If Saif Ali Khan is claiming maybe ownership of some huge bungalow or palace in Bhopal, it is because of his ancestors and there is no timeline for him to enjoy that or to inherit that. But you can't say the same thing in the case of patents, trademarks, and others. They have a limited shelf life. Bill Gates once famously said that the intellectual property has the shelf life of a banana. The shelf life of a banana. So, like the banana gets rotten after a particular period of time, intellectual property rights are also extinguished after a particular period of statutory term. Maybe, 10 years in the case of trademark, unless it is renewed, 10 years in the case of design, unless it is renewed for a maximum period of 5 more years. Copyright, lifetime of the author plus 60 years if author could be identified, otherwise 60 years. I'm talking only about India, please. Right? And plant varieties, their protection may range from 15 to 18 years. Patents only for 20 years. So ultimately, there is a limited shelf life. This is another important passage. Then, of course, the uniqueness of intellectual property is known to everyone because like any other property, we are talking about the human creativity, but coming from the mind, not from the hand alone. And intellectual property is a valuable asset, no doubt about it. If you say that Apple is the costliest brand in the world today, it has nearly 60% of the total, asset value of the Apple company. Only one trademark, Apple. That's a fact. Value asset. It can be owned like any other property. But only thing is, it is intangible. I mentioned about the information just now. It is intangible, which can't be seen, touched, or perceived. Then it is time and cost intensive. That is also equally important. I mentioned about the shelf life and all. Then there are certain additional profits. Periodically, for example, royalty can be spoken about, the patents, the trademark, so on and so forth. Periodical payment. Then there are certain special rights, not only commercial rights, but also special rights. And last thing is that even during the term of its protection, intellectual property will not remain only with the owners and stakeholders. It may be transferred, perhaps with the exception of geographical indications of goods, which could be inherited. This is another important point, please. Classification, you must have already discussed. Two broad classes. One is industrial property, in which we have the patents, trademarks, industrial designs, and GIs. I think that's not my concern today. The other one is copyright. You can call it literary property, which can touch upon the rights in respect of musical works, literary works, artistic works, maybe broadcasts, dramatic works, so on and so forth. So this is the second major classification. You can have a third major classification also. You can call it the emerging forms of intellectual property or new forms of intellectual property. So where you come across maybe plant varieties protection, though they are almost, 100 years old, but still in some jurisdictions, it's a recent one. Or layout and industrial designs. You can talk about life patents, business methods, computer programs, AI generated works, right? You can talk about, in fact, even internet copyright. So the new forms, emerging forms also can be referred to. Now coming to copyright protection and law. I don't know if all the participants are from the legal background, but at the same time, everyone needs to know the recognition of copyright and the need to protect it under the legal regime. Copyright, like any other intellectual property, is transnational in character. It goes beyond the national boundaries. And you will find that protecting the intellectual property in one country or only the country of origin will not, actually, protect it effectively, because it has to be exploited in more than one jurisdiction. The work which is created in India, a movie made in Hollywood, in fact, it needs to be exhibited throughout the world. If that is the case, it needs to be protected wherever the, in fact, copyright in that cinematograph film is exploited. So in order to ensure that the protection is uniform, the protection is concrete, based on certain basic principles, first convention was, made at the international level on copyright in the form of Berne Convention, 1886. Berne Convention on Protection of Literary and Artistic Works, 1886. In fact, it is next only to Paris Convention. Honestly speaking, copyright was the first intellectual property which was spoken about as far as the history is concerned. But internationally, the convention on the, in fact, the copyright came up after the Paris Convention was entered into in 1883. The basic principles are very clear. Whatever is the expression of an idea will be protected. Not the idea, but expression of an idea. Second principle is that there must be fixation of the expression onto some medium, whether it is literary work, artistic work, musical work, whatever. Third thing is that the copyright springs into existence the moment the work is created. So you need not register compulsorily. You need not, in fact, concretize it the moment it is created. If manuscript is created, copyright springs into existence. It need not be published in the technical sense. Similarly, there is something like principle of national treatment, like, no discrimination against the citizens of one member country against the citizens of other member countries as far as copyright protection is concerned. And these are some of the important principles which you will find under the Berne Convention. Then the Rome Convention comes up, in 1961. So that is almost about 75 years later, after the Berne Convention. But it touches upon a very interesting kind of, in fact, intellectual property, namely the neighboring rights. You can also call them the related rights. We are talking about the performers, the producers of phonograms, the producers of broadcasting, or the broadcasting organizations itself. That is 1961. We have the TRIPS agreement. The TRIPS agreement must have been already referred to, has revolutionized the way the world looked at intellectual property rights. And copyright is not an exception. Even with regard to copyright, the TRIPS agreement makes special provisions, and we talk about the protection of, in fact, the copyright for a minimum period of 50 years minimum. So some countries provide for 60 years, like in India, maybe 70 years in the case of US, right? Similarly, like computer programs being protected as literary works under the copyright law, so on and so forth. So TRIPS agreement is another benchmark. Then, in view of the emergence of internet, digital copyright needs to be protected. And we have two WIPO conventions, World Intellectual Property Organization-led conventions. One was WIPO Copyright Treaty, 1996. The other one is WIPO Phonograms and Performance Rights Treaty, 1996, same year. And very good thing is that India has incorporated all of them. India has been a signatory to Berne Convention since 1928. It has signed the Rome Convention. It is the original signatory to the TRIPS agreement. It has signed WCT and WPPT, and all of them are incorporated in the present copyright law. You will find the Copyright Act 1957 as the law governing copyright in India. This is the law which governs copyright. This has been amended any number of times. Last major amendment was sometime in 2012. I have 2 or 3 slides on this. But in order to protect digital copyright, in order to protect the rights of visually disabled persons, and in order to ensure that academic interest also is protected, right? Number of changes came to be made, and that is in the form of 2012 amendment, which is an essential part of the Copyright Act 1957. Before, I'm not going to explain about the salient features of this act. Anybody can go through them. Only 1 or 2 observations. Indian copyright law contained in Copyright Act 1957, as amended from time to time, is one of the most progressive or advanced copyright laws in the entire world. Much before the TRIPS agreement was talking about protection of computer programs as literary works under the copyright law. We already ensured that way back in 94. And in fact, we say that Indian copyright law, as contained in the Copyright Act of 1957, provides something called TRIPS plus protection, TPP. Whatever the TRIPS agreement insists on being followed in member countries of WTO, the agreement on trade-related aspects of intellectual property rights. In fact, as far as copyright is concerned, we have already included in the Copyright Act of 1957 in 1990s itself. Then it is supplemented by copyright rules, which are made from time to time. Probably 2020 rules are occupying the field today. Because we should know what exactly is the law that is governing the copyright. So this is the law. Now coming to copyright. I mentioned that when you look at the broad classification of intellectual property rights, originally there were 2 classes. One was industrial property, the other is literary property. Industrial property doesn't include copyright. So because it deals basically with the patents, the trademarks, the GIs and industrial designs. But when it comes to literary property, there are 2 subclasses in this category. One is copyright, the other one is neighboring rights. And copyright, as I already mentioned, is that kind of intellectual property which protects expression of an idea. You can look at the 3rd bullet. We are not worried about the idea. Idea will be one and same. Most of the ideas may not be original, but the expression of an idea might vary, right? Take the case of Ramayana, take the case of Mahabharata. Recently, one of my students gifted me a 10-volume set of Vivek Debroy's Mahabharata, Ramayana. I made to open it, 10 sets. Now the point is, whether it is Mahabharata or Ramayana, I'm just giving an example. You have different versions. If it is Ramayana, right from Valmiki Ramayana to the latest, right? Veerappa Moily also commented on this. Rajagopalachari wrote on it. Vivek Debroy must have written on it. What I'm trying to tell you is that idea will be the same. Expression will be different. And what copyright protects is expression of an idea. Expression must be original, not the idea. Idea may be or may not be original. That is the first point we should understand. Second thing is that this expression may manifest itself in different kinds of works, literary works. Now, Hyderabad Literary Festival is going on in Hyderabad. Many people have come from across the country, Rajdeep Sardeshai and many more. Now, they are trying to showcase their, the scholarship in different kinds of literary works. So, one can express the idea in the form of literary work, maybe prose, poetry, fiction, non-fiction, compilation, original, derivative, whatever. Or artistic works. Maybe, you are talking about, in fact, maybe painting, maybe sculpture and other forms. Your musical work, remember, Tyagaraja, onwards, Annamacharya onwards to the latest A.R. Rahman and many more, right? Anirudh Ravichandran, tak. Then dramatic works, computer works, photographs, equally important, photographs, and even cinematograph works. All of them are nothing but expressions of ideas. Whichever is suitable, whichever is more effective, that will be the expression of the idea. And that is protected by copyright. And there is a saying in our jurisprudence, one who creates something must own it. We are all teachers. We have been creating lot of literary works. You are writing an article, you are writing a review, you are coming out with a monograph, you are writing a book, you are editing a book, right? And maybe you are making an invention, whatever. You are writing a specification. At the same time, when the question comes to ownership of the intellectual property in it, whoever is the creator must own it first. And as far as intellectual property is concerned, copyright is concerned, it is the author, it is the creator who must own it first. Later on, it may be owned by someone else. That's a different issue. But author is the first owner of copyright. That's what Section 17 of the Copyright Act says. Section 17 of the Copyright Act, subject to other conditions, it says that author is the first owner of copyright. So we are all first owners of copyright. If you are working in Usmania University or Karnataka Central University or some other university, our university may not be the owner of copyright. Unless, we give in writing that, yes, university will have the copyright. We will continue to be the owners. Then copyright is not a single expression. Copyright denotes a bundle of rights. A bundle of rights. Many rights. Not right to copy alone. It includes right to reproduce, right to issue copies to the public or others, right to perform the work in public, right to translate the work from one language to other language, right to adopt the work into a movie, many more. And another point, whenever you read any book, any article, you come across at least C in a circle. C in a circle. Or you'll come across a word, all rights reserved. What does it mean? That means that copyright is reserved. Copyright is reserved. Now, the point I am trying to make out is that copyright may be reserved, copyright may be registered. In other words, it may not be registered also. It's your choice. But registration of copyright is not a must. It's not mandatory. And that is the precise reason why, many, in fact, teachers, researchers, they don't register. Whereas when it comes to assignment of copyright, etc. is concerned, there is a pakka agreement between the publisher and the author. That fellow will have some kind of standard form of agreement, whereas the teachers may not insist on that, right? But it is better if the copyright is registered. Otherwise, also copyright can be claimed, because I already mentioned, copyright springs into existence the moment the work is created. This is one more important aspect. Then copyright is one intellectual property with the longest tenure of protection. If shortest tenure may be like design, maybe only 10 years plus extendable by 5 more years, the longest tenure will be for copyright. Lifetime of the author plus 60 years. If author is identified, if he is alive during his lifetime, plus 60 years. And if author is not identified, then it is 60 years. I am talking about the Indian position under the Copyright Act of 1957. If you go to USA, it may be 10 more years extra, 70 years. Lifetime of the author plus 70 years. Recollect that I stated about 50 years as the minimum term of protection under TRIPS agreement. Minimum 50. It can be maximum 60, 70, who knows, it may be 100 years also, depending on the member's discretion. That is another important aspect. And if an artificial entity is owning copyright, it may be only 60 years. Government may have it only for 60 years. A private organization may have it only for 60 years. University may have it only 60 years, right? And like any other intellectual property, or for that matter, even traditional property, the copyright is heritable and assignable. It can be inherited, it can be assigned, it can be even transferred. Assign means nothing but transfer. You can assign the right, maybe right to publish, maybe right to make a movie, right to, in fact, communicate, and the right to translate, all of them. And last point is, I think it's very interesting. Somebody rightly said, at present, the copyright is not concerned only with the lonely, starving authors. That was the time when there used to be, authors and stationers in countries like United Kingdom, England, right? And then the focus was mostly on the rights of the publishers than the rights of the authors. But today, the copyright is the concern of the information technology industry, IT industry. We are talking about the publishing industry. We are talking about the entertainment industry. Look at what's happening between Nayantara and Dhanush, right? I'm saying in the lighter vein, it's a very small issue. And look at what is happening between the Indian publishers on one hand and GPT chatbot OpenAI on the other hand. Only 2 days back, there was some impleachment petition in the Delhi High Court, because for training purposes, they are using published works of, publishers like Yes Chand, Pearson, so on and so forth. So it's a major industry today. It is no more the concern of lonely, starving authors. There are huge economic dimensions to the copyright protection. This is another important aspect. Now the question is, what can be the subject matter of copyright protection? What can be protected? I had an occasion to visit Delhi on 22nd of this month, just a few days back. Maybe some of you must have visited. There was a program called the GI Samagam, Geographical Indication Samagam, organized by the DPIIT, Ministry of Industry and Commerce, in association with India Today. Bharat Mandapam, wonderful program, attended by Mr. Piyush Goyal, the Central Minister, and many experts, then authorities and all. Fine. Now the point is, one of the resource person was trying to say, why don't we give a GI tag to Kuchipudi dance? Geographical indication tag to Kuchipudi dance. Initially, I felt like laughing at that suggestion, because normally geographical indication tag can be given only to agricultural, natural, or manufactured goods. I don't know whether dance could be, considered as goods. It's not goods, right? And at the same time, there are people who say that you give copyright to yoga poachers, give copyright to Kuchipudi dance poachers, right? Give copyright to maybe, the way dialogue is pronounced, Jhakas, Bidu kind of thing, right? So all of them bring us to the main question. What can be copyrighted? What can be copyrighted? That's on your screen. Subject matter of copyright protection. Just look at section 13 of the Copyright Act, which deals with subject matter of copyright protection. And there you will find that literary works are copyrightable. And mind you, most of the academic works fall within the meaning of literary works. Whether it is including question papers, examination question papers, answer scripts, right? Dictionaries, then, in fact, articles, monographs, whatnot, and other literary works, prose, poetry, this and that. Literary works, including the computer programs. The computer programs, you know very well. The set of instructions given to a computer for performing a given task, blah, blah, blah. So don't think that computer will be only in the form of a PC or something in the computer lab or desktop. Your cell phone is your computer, your watch is your computer if it is electronic. So computer programs are also part of the literary work. Then dramatic works, the stage plays, right? The scenic arrangements, so on and so forth. They are part of the drama. dramatic works. Musical works, we are talking about, not the lyrics, not the action that follows, but the work of music, the music, the concord, discord, whatever it is. So all the musical works. Then we have artistic works. We are talking about paintings. We are talking about sculpture. In fact, we are talking about inscriptions, so on and so forth. Sound recordings. We are talking about phonograms. So the entire music industry is dependent on sound recordings, whether it is tips cassettes, whether it is T series, or Sony, Saregama, BGM, this and that. So sound recordings, phonograms, films. I'm talking about cinematograph films. You have a blend of copyright in it. Pushpa 1, Pushpa 2, or whatever it is, or Animal, you name it. You have so many departments, 24 frames. Each frame will have some copyright or other, right? So maybe musical work, artistic work, performances, story, everything. They are also copyrightable. Broadcasts are copyrightable. Because yesterday, the on the occasion of the 26th January, so there was a very grand display of the Indian culture, achievements, so on and so forth. The broadcast was made. That was official broadcast, right? And probably if Doordarshan so wants, it can copyright it. It can have the broadcast reproduction right. I think it has. Same is the case with cable TV programs and many more OTT platforms. Everywhere you come across copyright. This is another important facet, please. Now, let's talk about the nearest kind of subject matter, or the nearest subject matter, which is, related to the academia, the universities, the teachers, the scholars, the students, the publishers, so on and so forth. Literary works. And what is literary work? As I already mentioned, literary works include the works of literature, the databases, the compilations, including the computer programs. And in these literary works, copyright includes number of rights, exclusive rights, which are given to the author initially. If he transfers it to someone else, it may be the owner, right? So you have the right to reproduce. If you are publishing an article on your own, you can publish it any number of times, right? Then same is the case with any publisher. To reproduce the work, then to issue copies of the work to public. So it's up to you whether you want to publish, communicate or not, to perform the work in public. And if I am the copyright owner in respect of literary works, I can perform the work in public. I can communicate the work to public. I can make a movie based on cinematograph films, right? Or sound recordings. You ask, one of the celebrated Hindi.
Sir,
Yes, please.
sorry to intervene, sir. Sir, the participants have saying that slides are not moving.
Not moving.
No, sir.
No, even now.
No, sir.
Where did we stop? Okay, just a minute. How come slideshow? Through. Just a minute.
Yes, sir. Yes.
Just a second. I'm forwarding it to you. Mr. Jayanto, just a minute.
Yes, sir.
I'll forward it to you. anyway, it will be part of your record also. Just a second. I've sent it to your mail ID, Dr. Jayanta. Then I will once again try to, in fact, share with you. Just a second. Maybe, yes. Okay.
Sir, that slide is in Google Drive, I guess, sir.
I am technically a little.
Yeah.
Anyway, I've
So-
shared with you because, very unfortunately, I'm sharing my screen again and again. There's some problem here. Okay, just a second. Yeah. Anyway, I'm dealing with, which slide I'll tell you. Maybe slide number 10. Mr. Jayanto, you can present it for me if it is possible for you.
Sir, Jayanta sir is not in the meeting. Some
Anyway, you.
network- Yes, sir, I will do it, sir. I am doing it. I have contacted him.
Okay.
Yes, sir.
Is it shared?
It was displaying, sir. Again, it went away.
It was displaying, yeah?
Yes, sir.
Okay. Share. Can, is it visible?
Yeah, now it is coming, sir. Let us wait, sir. Coming. It
Okay.
is coming.
Okay. The subject matter of copyright protection is there on the screen?
No, sir. It is not clearly visible. You are there for half of the screen, sir. So rest of the screen.
Okay. I think I'm just a minute. I think now full screen is coming up. Stop sharing. Just a second. Yeah, I think you can see it now.
No, sir.
This one. Now it is full screen on. Full screen I can see.
Sir, sorry, sir. Please give us 1 minute. We will.
Yeah, yeah.
Yes, sir.
I'll stop sharing. Then you can do the needful.
Krishna, I have shared to your mail ID. Have you got it?
No, sir. Sir,
Just now. I have also forwarded it to the Department of Law mail ID also and to your ID also.
okay, sir. I'm checking, sir. Sir, no, sir. I
You,
have
you
not.
can see it now?
Yes, sir. Now it's good, sir. Yes.
Okay, I'll share like this. Fine.
Yes, sir.
Now it's moving, no?
Yes, sir. They're
Okay.
changing.
Okay. I think I was here. Subject matter of copyright protection. When I was talking about the copyright in literary works, here I stopped. Kindly recollect that we are talking about the various rights that emerge out of our literary works. And I also already said that our academic contribution falls within the meaning of literary works to a great extent. That can be, in fact, reproduced. That can be the subject matter of issuing copies to the public. It can be performed in public. It can be communicated to the public. Then one can make a movie. You remember Manu Bhandari's case. Manu Bhandari, the eminent novelist, Hindi novelist. In fact, she filed a case way back in Delhi High Court, long time back, about Aapka Banti, one of the movies which was made, Samay Ki Dhara, about the moral rights. So that is another important aspect. Then, anyway, we have right to translate and adopt. Coming back to another important aspect, you may recollect that the ownership of the copyrighted work becomes very crucial. So when we are talking about the, in fact, the ownership, Copyright Act is very clear about it. Under Section 17 of the Copyright Act, it categorically says that author shall be the first owner of copyright. Author shall be the first owner of copyright. So when the author is the creator here, I must say a few words about the author. Don't think that author means only the writer. Author can be considered as the creator. A painter is an author. A computer program is an author. Programmer is an author. A writer is an author, right? A dramatist is an author. A music composer is an author. Legally speaking, the definition of author encompasses all these. So, unless there is an agreement to the contrary, author will be the first owner of copyright. So, if you contribute something, you are the first owner. Suppose your article is accepted for publication in any journal, they will send an assignment sheet, assignment of copyright in the prescribed pro forma. Only when you sign, then only they will publish. Because after that, the probably ownership of copyright changes. They want the ownership to be vested with the publishers. Then who is the author? For example, in case of cinematograph, film, sound recording, musical work, whoever is the producer of such work is the author, right? And same is the case with others. And copyright can be assigned because there can be first ownership of copyright. For example, I'm writing an article on the occasion of 75 years of the Indian Constitution, right? I send it to the Hindu English Daily, and I am the first owner of copyright. Suppose, it is published by the Hindu, he wants my assignment to be made. After that, he may be the second author, second owner, not author, second owner. I may be continuing as the author, but my ownership will be transferred. He will be the owner. Same is the case with any publisher, right? A cinema story is written. The author is the copyright owner. But once he approaches a cinema producer to make a movie, if the producer is interested in making a movie based on that story, then he might purchase. He might get the assignment in his favor. He will be the owner. Author may be continuing as the original author, likewise. And the assignment is very important. So when you are talking about assignment of copyright, it can be made either in respect of the original works or in respect of the future works. So original works which are already created, existing works. Or suppose you may agree for writing a book, there can be a future work also in respect of which assignment can be made, but it will be enforced only when that work comes into existence. Without the work, probably copyright cannot be enforced, right? Then copyright term is for 60 years, remember. And you can give the assignment only for 5 years, only for 2 years, only for 10 years, or maybe for the entire 60 years. It may be for the whole of the term, or any part of the term. And every assignment must be in writing, must be signed by the person who is the author or his authorized agent. Then what is transferred also is important. What is assigned also is important. For example, you are writing something in English language. And normally, if you want to give copyright in respect of English language, you will mention. But suppose you want to reproduce the same in Telugu language, you can retain that. Copyright can be split in that sense. Similarly, territory, where the copyright has to be exploited. Of course, today is the age of globalization. People are talking about, in fact, international publishings like Springer Publishing or Thomson and Reuters Publishing and all. Fine. But if no territory is mentioned, it is deemed that it is in India only. If no time period is mentioned, it shall be deemed that it will be only for 5 years. After that, the author can get back the right. So this is very important point. Then another important aspect. How do you manage the copyright? What is important is this. If an individual is managing, probably it will be difficult for him to manage. I'll tell you how. In our academic community, there is a famous saying, publish or perish. Publish or perish. If we don't publish, what happens? UGC people will not keep quiet. There will not be any career advancement. And we may not move into the next scale or go to a better position. So we try to publish in maybe some, publishers, independent publication, or some, paid journal. This is the necessity. Most of the teachers do that, which may not be correct. UGC care listed journal, Scopus indexed journal, Elsevier and all. Fine. But at the same time, when we want to protect our rights, it is an uneven world. And that is the reason why in the context of academicians writing something that may be different. But suppose music composers, they can come together and form a society, right? Singers can come together and form a society. Music companies can come together, form a society. Artists, the actors, etc., can come together and form a society. Ultimately, there is a provision for collective management of copyright. And societies can be formed. There is a provision for copyright societies. For example, IPRS, Indian Performing Rights Society. So this is one of the oldest, organizations registered as a society. Recently, it was given, few days back, it was given a renewal of registration. Otherwise, it was stopped after 2012. And here the actors can complain about the violation of their copyright or unreasonable terms with regard to the royalty paid to them or money not paid to them, whatever. Similarly, you have PPI, PPL, that is Phonographic and Performance Limited. This will be issuing licenses, music reporting, documentation, distribution, so on and so forth. In fact, this PPL was, after the persons who were performing the weddings and other things by playing the copyrighted music. Recently, the government clarified that playing music, even though it is copyrighted work, on the occasion of any festival or wedding, etc., may not violate copyright because it is not for commercial purpose, only for entertainment purpose. Similarly, the Society for Copyright Regulation of Indian Producers for Film and TV, Script. Then we have Indian Music Industry, one of the oldest copyright societies, which consists of so many music companies, and Indian Singers Rights Organization, ISRO. And in fact, singers also have a platform. So this is collective management of copyright, which can be ensured under the copyright law. Now I'll come to another important aspect. That is, the term of copyright. So what exactly is the term of copyright? For example, in published musical, artistic and other works, term of the copyright is, it is until 60 years, after the death of the author, lifetime of the author plus 60 years. Suppose there is an anonymous work where the author is not identified, or pseudonymous work identified but real identity is not known. Posthumous work published after the death of the author. In such cases, normally it is 60 years. In case of sound recordings, it's only 60 years from the beginning of the calendar year subsequent to the year of publication. Another important aspect, I think this is equally important. What are the rights of authors? We are all authors. We keep on publishing. What are our rights? Generally, we have two kinds of rights. One is economic rights. The other one, the moral rights. You can also call them special rights. Economic rights, as the name itself suggests, are the rights in respect of which there is an economic incentive. When we are publishing 500 copies of the book and we are selling it through Amazon, then you can simply say that, it is, in fact, for a particular gain. Similarly, to issue copies to the public, that is also a right, to issue copies to the public, because for that there will be an economic gain. To make a cinema, because the story is the heart of any cinema. Suppose, that is the basis for making a cinema, the story writer will be paid. It's a moral right. To perform the work in public, it's not free of cost. Many times it may be for a consideration, translation, adaptation, all of them. And one more important aspect, there is something called resale share right. Resale share right. So what is this resale share right? Resale share right normally denotes that even after selling the copyrighted work, selling the copyright, suppose that purchaser, the original purchaser, sells it for more than 10,000 rupees to someone else. For example, I write a book, you write a book, you sell it, you totally transfer the copyright for, let us say, 50,000 rupees to a publisher. The book becomes very popular. Then that publisher wants to sell it to some international publisher for 5 lakhs. Logically speaking, we will not have any right because we have already sold. But Copyright Act says that there is something called resale share right. So when you say resale share right, that means having a share in the resale price. If it is more than 10,000 rupees, we can claim, in fact, 10% of such resale share. So this is also an economic right. But apart from that, we also have certain moral rights. Moral rights are independent of copyright. Whether there is copyright or no copyright, even if the copyright term has expired, even then, even if we transfer the copyright in favor of XYZ, even then, the authors can exercise two important rights. You can call them paternity right, that is right to be recognized as the author. Even if your book is published by the publisher A, publisher B, publisher C, doesn't matter, but still you will be the author. Your entitlement to be known as the author continues. Similarly, there is something called integrity right. Okay, you transferred the copyright, you assigned the copyright, but that transferee to whom your rights are transferred is not eligible, not entitled to mutilate, distort, revise drastically, which might affect your reputation as the author. So your reputation, your honor, they are equally important. So your work cannot be distorted. So right against distortion, mutilation, undue modification. So this is also integrity right. It's a part of moral rights. Two moral rights. One is paternity right and the other one is integrity right. So this is one important aspect. And these rights can be claimed by all the authors. The latest is that even performers also. Even performers also. Who is a performer? I will try to tell you. One point is that we are all performers. When we go to the classroom, we are not, inferior to Amitabh Bachchan or, Tom Hanks or Rekha or Deepika Padukone. I'm saying in the lighter way. We are all performers. We are all, entitled to the rights of performers as under the Copyright Act. I think that we can discuss after a small bio break of for about 6 to 7 minutes. Now, I think it is 3:12 in my watch. Shall we meet at 3:20?
Yes, sir. Okay, sir.
Yeah, exactly 3:20 we will log in. Until that time, I will be online, but I will just close my camera and
Thank you, sir.
Hello, Krishna Kumar.
What's happening? I can't hear anything. I can't see anything.
There is some pop-up message.
I'm not able to hear anything, but I can see the screen.
Sir, you should have been following the session
So there
because
is a
sir
pop-up
has given a
message.
brief.
Yeah. So it is break time. So what is that pop-up
Okay.
message? Like you could join YouTube. So
Yeah, I don't
something.
have an account on YouTube, so I
Yeah,
can't
that's
see
what.
it.
So what is that account? Whether it is from organizer or what kind of message it is that we don't
Yeah,
know.
exactly. I have the same question.
Sorry,
I
what is that message?
I have the same question. Even I am getting that same pop-up.
No, this is the activity on YouTube. They are asking to join you on YouTube, but no idea what this is. And when you click on it,
So
it takes you to YouTube, but nothing happens. Simply,
yeah.
I left it. Yeah.
I to join it, but
Yeah.
nothing is happening over there. I don't know what is
Yeah.
that.
Anyways, I have left that. It's not part of our activity. Means
Very true.
we were
Very true.
only to be hosted on Gmeet. That's the agreement. Will not go to any other platform.
Yes.
Okay. So this is the break. So I should take the break now. Okay. Thank you.
Dear participants, sir will join in a minute. We will start the session again.
Yeah, welcome back. Uh, Sorry, I'm late by a minute. Am I audible?
Yes, sir, you are audible, sir.
Yeah. So I was talking about these two kinds of rights. We must always remember that our economic rights are only during our lifetime plus 60 years after our death. But moral rights are, even if Shakespeare's rights, for example, Shakespeare is no more, must have died more than 400 years back. But in respect of his works, now there is no copyright. Anybody can make a, in fact, publication, anybody can make a movie based on that. But nobody can say that instead of Shakespeare, I am the author. Because that paternity right is a moral right, which is vested only with the author, not with others. Now, this is another important point because we are all, in fact, teachers. Everyone talks about Swayam courses, MOOCs, right? Or NPTEL classes. And nowadays, I think online teaching has become an integral part of higher education system. Then we are offering our own classes, own video lessons. Then sometimes even live programs are, broadcast. All of them are relevant to something called neighboring rights. So what are neighboring rights? We call them neighboring rights because they are neighbors of copyright. How, for example, what can be a sound recording? Sound recording or phonogram is in respect of a musical work, a literary work, right? A cinema, all of them fused together. Since they are independent, they are related to copyright, they are called neighboring rights, also related rights. Similarly, performances. In respect of performances also, we can go for that, right? In respect of performances. For instance, we have, take the case of an actor, a singer, maybe a teacher who is giving a, live performance. Then similarly, a juggler or a snake charmer or any person who is doing something live. If I'm giving a lecture live, now the question is, I'm a performer and I have certain rights in respect of my performance. Now you are recording it because I gave permission. Maybe it is part of my assignment. But suppose there is no such assignment, no such agreement, it cannot be recorded without my permission. Your classroom performance cannot be recorded without the permission of yourself and your college, right? Remember, so these are all performances. I'll come to that. And the beneficiaries of such neighboring rights are broadcasting organizations, whether it is BBC or All India Radio or Vivid Bharati or FM radio, whatever. And similarly, performers. And right from Amitabh Bachchan to even, somebody like a snake charmer, they can claim, in fact, performers' right in respect of performers. And here the term of protection varies. If it is a broadcast reproduction right, R is missing over there, it is for 25 years, right? Broadcast reproduction right. Take for instance, yesterday, in fact, Doordarshan telecast the Republic Day celebrations in the morning, parade and all. Fine. Now it will claim broadcast reproduction right. They can reproduce the same for next 25 years on Doordarshan without, asking anyone. Any number of times. That is broadcast reproduction right. Performers also will have certain rights in respect of performances given by them. And maybe the next slide will explain a little further. Coming to broadcast reproduction right, I already mentioned that it includes right to rebroadcast. I'll give you another very live example. When 15th August comes, 26th January comes, most of the television channels will be telecasting only the movies with patriotism as the theme. In Telugu, in English, in Hindi, or any regional language. And maybe if you observe carefully, during the last so many years, 10 years, 15 years, 20 years, same movie must have been rebroadcast any number of times, retelecast any number of times. That is because for 25 long years, that channel can reproduce, rebroadcast the, in fact, the film. or broadcast or sound recording. Then similarly, to make a sound recording, to make a visual recording, to make a reproduction of such sound recording, or in fact to sell or hire to public regarding the sound recording, all of them are part of the broadcast reproduction right. You can apply it even to the Swayam courses, right? When you talk about the Central Educational Consortium of Educational Communication, CEC, you talk about NPTEL, you talk about something like ePathshala and many more, you will find that your performance is recorded, then it can be telecast any number of times through any of these channels like Swayam Prabha, etc., etc. Their broadcast reproduction right comes into picture. Coming to performers and performances. Question is, who is a performer? You can see the definition there. It can be an actor, a singer, a musician, a dancer, an acrobat, juggler, conjurer, snake charmer, a person who delivers a lecture, and any other person who makes the performance. But what is important is the performance must be live. If it is recorded, then it's not performance. If it is a live performance, right, real-time situation, in such a case, it can be called performer, performance right. He can be called a performer, and performer's rights include the following: right to make a sound recording. A small example. One can record my lecture, whether it is good, bad, or worse, doesn't matter. But I have the right either to permit or not to permit the sound recording or visual recording of my performance, or to broadcast my performance or not to broadcast my performance. And similarly, to communicate the performance to public, otherwise than broadcast. So to communicate the performance also, right? All of them are part of the performer's rights. And what you need to understand is that a lecturer is a performer. A professor, associate professor, assistant professor, visiting faculty, expert, whoever it is a performer in the classroom, is a performer in the laboratory, right? Then another important point. We are living in the age of infringement. People are talking about infringements, piracy, counterfeiting. Nobody is really interested in creating something new. It may be looking like a sweeping statement. The fact is that very few people are harping on originality. Others simply copy. In the case of copyrighted works also, there is every possibility of copyright being infringed or violated. Right? And what is infringement? Let us see. Section 51 of the Copyright Act. It talks about, for example, without any license, or even if there is a license in violation of the terms of license or conditions of license, if anything is done by a person, for example, I give license to so-and-so publisher in Tamil Nadu to publish it in Tamil only in respect of my work. For example, he publishes in Tamil as well as Malayalam. It is clear violation of my license right. It is infringement. Okay. So, or simply somebody is publishing your work without your permission. Simply they are making use of your name, but they are publishing on their own. That is also clear violation of copyright because you have not given any license. You have not assigned any copyright, right? Then similarly, another point, permitting for profit any place to be used for communication of work to public. For example, in the good old days, the pirated CDs, compact discs, DVDs, etc. were made by renting houses. So when a new movie comes into the market, then pirated copies used to be made. If allowing a premises to be used for that purpose, that is also infringement. Similarly, without any permission, without any, in fact, license, if somebody is selling, hiring, or, in fact, displaying certain, in fact, maybe posters, maybe, in fact, inlay cards, etc., that also becomes, in fact, infringement. Distributing, for trade purposes without any license. Then similarly, importing it into India. For example, there is an infringing copy. If you are importing it for commercial purpose, then it may be infringement. Or book piracy, we have already seen reprinting of the books illegally without any permission. Then similarly, another important point are publishing the books in the name of famous authors. Authors may not be there, but I'll give you one or two examples. Then producing translated versions of foreign language books. I think that's the easiest to do nowadays. People want the foreign language books to be, in fact, translated into different language books, because piracy is quite common, and piracy is different from infringement, especially when people copy from others' works and publish them as their own. It might become plagiarism also. I'll come to that a little while from now. But at the same time, kindly remember that copyright is not only for protecting the commercial rights of the authors or the owners of copyright. Copyright is meant for even preserving the culture, passing on the information, right? It can be used for educational purposes. So therefore, many exceptions have been carved out, exceptions to infringement. They have been carved out and they have been, in fact, recognized. You will find them under section 52. For example, you are making use of a copyrighted work for research or private study. That may not amount to copyright violation. It is fair use. We call it fair use or fair dealing. Similarly, we are making, large copies or large portions copied from a published work without permission only for the purpose of criticism or review. That may not amount to copyright violation. Similarly, reporting of current events. For example, there is some flash news, breaking news, and something happens somewhere, maybe in Prayagraj, where Kumbh Mela is happening, and only one particular author, a particular TV channel or particular publisher is available, and he or she is displaying the information. Telecasting similar information, copying from that link, or publishing similar information only for the purpose of reporting of current events will not amount to infringement of copyright. Similarly, using something for judicial purposes, judicial proceedings, or some amateur club people making use of copyrighted work, not for commercial purpose, for self-entertainment. Then similarly, for example, with regard to persons with disabilities, we are talking about, in fact, visually disabled persons. Suppose they are converting regular works into Braille so that they can get access to that information. And in such a case, if they are doing it only for learning or dissemination of the knowledge, that too on a non-profit base, without any cost, right? Only the cost of production may be recovered. In such cases, it will not be amounting to infringement of copyright. Take the case of cinema. Cinema, I think you have any number of, instances where the latest movie is accessible on the cell phone of many youngsters. They have number of websites, maybe dark web, light web, I don't know, right? But you will find that the owners of copyright in a cinematograph film, they have certain rights, like, cinematograph rights. Then similarly, they have rights like video rights, cable TV rights, commercial rights, satellite rights, musical rights, maybe theatrical rights to exhibit the same in a theater, non-theatrical rights, then public video rights, satellite communication rights. There are so many. So if any of these rights are violated, it becomes cinema piracy. Ultimately, the pirates will be criminals who will be booked under the law. Now I am coming to a very important aspect. We're talking about impact of the Copyright Amendment Act 2012. And if you analyze this Copyright Amendment Act, because I mentioned that Indian copyright law has been very progressive. It is well ahead of the laws relating even to some of the developed nations. But when the information technology revolution took place last century, then the digital copyright or internet copyright, etc., have emerged. Digital rights management system has come in. Rights management information system has come in. Then there was an imminent need to amend the existing laws. How they have, in fact, amended, and the major changes made by such amendment are on your screen. The major amendment was in the year 2012. For example, performers. One of the changes made by this amendment is that today the performers also have moral rights. For example, I teach in a particular manner. Somebody acts in a particular manner. Certain mannerisms, dialogue delivery. Suppose somebody is trying to distort these or trying to mimic my voice for some illegal purpose. Somebody wants to make use of Amitabh Bachchan's voice for gutka purpose, advertisement, for which he has not approved. All of them today are covered under the Copyright Act of 2000, Amendment Act of 2012. Then there is a concept known as technological measures. What is technological measures? Today, it is quite easy to violate copyright. Any person with basic knowledge can easily violate copyright. One can take a photocopy, one can remove that watermarking system, one can easily crack into the password system, username, password, right? Therefore, certain measures are taken up, like encryption and all, digital signatures, electronic signatures. Combining that with the rights management information. For example, when you purchase a smart TV, when you subscribe to some OTT platform, maybe Amazon, maybe something else, so you have number of things to perform. Simply by giving your number, you will not get. There may be an OTP or whatever it is. So rights management information also is, explained. Then another important point, copyright meaning is given under the Copyright Act of 1957, especially under Section 14 of the Copyright Act. So today, the meaning of copyright has been expanded, I must say, expanded. And that includes right to store works in any medium by electronic or other means. We make a backup copy, is it not? Or we make an electronic copy, digitalized version or whatever it is. Today, it is part of the copyright. It may be a security against the loss of the original copy or whatever it is, but still that is part of the copyright's definition under Section 14. Similarly, future technologies. See, today the technology always evolves, and in fact, it changes very rapidly. Today, for example, I am assigning copyright in favor of my publisher to publish in only book form. In future, technology comes only online publishing, no book publishing and all. So can my publisher say that anyway you assign copyright to publish in book form? Now we will also publish in any other form, maybe in the form of a CD, DVD, this and that. Some new technology comes even in that form. This amendment says if you want to assign in a future, time, then by using future technology, then you must enter into a special assignment subsequently, fresh assignment. Old one will not work. Then similarly, authors of certain works in cinematograph, films and sound recordings. This is important. Here I will tell you a story. There was a music director by name Ravi who composed music for many Hindi films, maybe few Telugu films and Malayalam films also. A very melodious music composer. But there was a story in the newspapers about maybe 15 years back, around 2011 or so, stating that he was in a very poor condition. There was no one to take care of him. And the kind of music he composed, which is sold by the producer to some music company to someone else, whereas they earned crores of rupees, he didn't get anything. And that came to the knowledge of Javed Akhtar, who was a Rajya Sabha MP at that time. So therefore, he in fact took the initiative to ensure that, for example, if somebody is writing lyrics for a particular movie, for writing the songs, similarly, somebody is composing music for that movie, somebody is writing a script for that movie, right? Or somebody is composing a sound recording for that movie, then they will be paid certain amount of money. Fine. The publisher or the producer, in fact, producer gets that, assignment in his favor only for using all these works in the cinema. Suppose instead of using cinema, or even after using in the cinema, music is sold separately, musical rights, overseas rights are sold separately, or script is sold separately. I'm talking about the non-theatrical use, not in the theater, but outside the theater. And producer is making huge profits. But the original, in fact, maybe the authors, the music composers, singers, etc., are not getting anything. If that is the case, now latest amendment says that there cannot be any assignment of copyright. If you want to use all these works as part of the cinema in a theater, you have every right. But if you want to use them outside the cinema theater, you must share royalty with the original music composers, original authors. So that's a good one. It is called Javed Akhtar's initiative. Previously, photographs were protected only for 60 years. That was the term of copyright protection. Today, it is the lifetime of the photographer plus 60 years. That is another important change. Similarly, persons with disabilities, now they can make use of copyrighted works, as an exception. Then there is something called statutory license. Statutory license normally, for example, X is a music company, Y is another music company. They will be coming out with the sound recordings. Suppose X company has musical rights in respect of a popular cinema. Hum Aapke Hai Kaun, long time back, 1996, almost 30 years back. Suppose the music of the cinema was sold in millions of copies. If Y company, music company, wants to compose music just like that of X company, which is producing the movie music, and it is used, the next company is using similar voice, similar tone, but with different singers, different musicians, what happens is that it will be a poor man's copy. But still, such versions were known as cover versions. These cover versions were, in fact, regarded as exceptions to infringement of copyright under the Copyright Act before its amendment in 2012. So now many music companies, made a hue and cry. They have been saying that we purchase the musical rights from the producers and others at a huge amount of money. Because of our popularity, the other fellow, my neighbor or my competitor, even though he is a small man, he is paying some peanuts to us, but he is producing similar music using different singers, different musicians, thereby affecting our economic right adversely. This was addressed by this amendment. Now, under Article 30, Section 31C of the 2012 amendment, it categorically says that one must wait for 5 years to prepare a cover version. Then, even if anyone wants to, in fact, produce the other copy, the copies to compete with the original music, in fact, company, minimum 50,000 copies. Royalty should be paid only for minimum for 50,000 copies. It's not that easy, right? This is another important aspect. Then similarly, in fact, number of exceptions have been broadened. Last point is important here. You can see the copyright infringement for benefit of academia. It is broadened now. For example, you can look at publication of compilations. See, normally we come across a concept known as derivative works, compilations, collection of works existing somewhere else, right? Now, that particular old statute has been deleted. Now the new statute says that previously it was called for educational institutions. Now we are saying for instructional purposes. That means for teaching purposes, we can compile the works of many and we can make use of them. Here I will try to explain a Delhi High Court judgment, but towards the end, about the course packs. Course packs. Then another important aspect. There is a new section. Section number is not important, but at the same time, the storing of a work in any medium by electronic means by a non-commercial public library. That means a public library which is not commercializing. Then if it is producing any non-digital work, non-digital copy of the work, it will not amount to violation of copyright. What is important is that public libraries have the right to digitalize and make them available in digital form to the users. So it serves larger public interest, please. And this is another important issue I would like to highlight. Because today, many people are very skeptical about the quality of research which is going on in many of the higher educational institutions, right? Here I am not pointing out any particular institution. So everywhere it's the same thing. And people always talk about something called plagiarism. Plagiarism. So what is this plagiarism is the question. Plagiarism comes from a Latin word called plagiare, means to kidnap. Simple logic. If we are kidnapping others' language, others' ideas, others' thoughts, right? And saying that it is our own, that amounts to plagiarism. If my neighbor has written 10 pages, I simply take 8 pages out of him and write that I am the owner, I am the author. That is plagiarism. And please remember that either in writing the PhD thesis or LLM or any PG dissertation, project report or assignment, etc., we must be very careful because today, in fact, one can search the publications which are already in public domain or the submission of previous thesis or dissertations in the past. And you have a link called Shodh Ganga link. Inflibnet has entered into this MOU with a number of universities. And the moment you want to find out any topic on which research has been done and submitted, you can search in Shodh Ganga, you will know. So many people, in fact, they try to overcome this difficulty, but nonetheless, many of them indulge in something known as plagiarism. Means simply kidnapping others' work and claiming that it is our own work. And there are different kinds of plagiarism. We have something called complete plagiarism. Thanks to the information technology, we have copy and paste quite easy nowadays. Control C and Control V culture. And similarly, word switch, because you have spillbot, quillbot, something like that. You put 75 words or 150 words, then it will give an output with the same meaning but different words, right? And self-plagiarism, that is also in fact prohibited by the UGC regulations 2018, because we can't plagiarize our own version. Suppose I published my article on a particular topic 10 years back. Now I can't say that anyway, now nobody remembers what I published 10 years back. Let me take major portions, anyway, my own publication. Now let me recycle, republish. That is called self-plagiarism, which is illegal. And plagiarism can be either intentional or unintentional. Most of the times it is intentional, wanted. Sometimes it may be unwanted also. But many people question why people go for plagiarism. They have a lot of time, they are given good salaries, good incentives, but still why do they steal from others? These are some of the reasons. Laziness, and lack of time, because many people are too busy with their avocations. There is no time, lack of planning, fear of failure. They feel that, if they write, they may fail. Therefore, they copy. Competition, because parents, family, and even colleagues will be pressurizing, right? Lack of knowledge. Many people do not know that plagiarizing is an illegal act. Lack of enforcement. Sometimes we may come across many examples wherein university knows that there has been plagiarism, but still no punishment is given. Pressures to publish, I already mentioned. Nowadays, we are thinking about the statement, publish or perish. If you publish, then only you will go to the next level. Senior assistant professor to senior assistant professor, from there to associate, from there to professor, from there to... So, publications become vital. So, because of lack of time, lack of preparation, lack of drive, people do all these things. Then desire for getting recognition. Almost in every human being, you come across a feeling that he or she must be recognized as an intellectual. So they think that by writing books, people are recognized as intellectuals. So that is also one of them. Maybe to influence others, that is also equally important. By giving one book to many important persons, saying that I am the author, I arrived, maybe it will be influencing others also. Now, plagiarism I've already mentioned. And there is something called intentional plagiarism. Deliberately plagiarizing others' works. For example, copying others' work is plagiarism. Copy and pasting a web page. Normally, we go to a web page of a website, then we download or cut, copy, and paste somewhere else. That is also intentional, deliberate. Ordering and downloading a paper. Nowadays, papers are for sale, Scopus indexed and all. So simply we purchase by paying $30 or $40, and we think that it is our own. We'll try to make use of it. Sharing a paper via email, that is also intentional plagiarism, because it may be for academic purpose, but still we have not taken any permission. Then cutting and pasting blocks of text from electronic sources. So what happens is that you enter into the websites of 10 different institutions, take one para from here, second para from there, third para from somewhere else, compile and say that it's my original. Right? That is also intentional plagiarism. Then media borrowing, web publishing without permission of the creators. These are the instances of internal plagiarism, intentional plagiarism. But there can be unintentional plagiarism also. Even without understanding that we are, in fact, indulging in plagiarism, we may also do certain things like careless paraphrasing. Careless paraphrasing means what? Just a second. Where did it go? Is the slide visible?
No, sir.
Just a minute. I think it has gone. Yeah, it is visible now.
Yes, sir.
Just a second. Just a second. Yeah, because what happens is that when we borrow without any authorization from others' works, let me also confess something, with my colleagues now who are online, that cent% research work can never be cent% original research work. That will be only a wishful thinking. Normally, any research work consists of three components. One is summary. We may read 10 or 15 pages, then sum up within maybe 1 page or half page, depending on that. Then there is something called paraphrasing. Paraphrasing using different language, different, if not language, but different words, different synonyms and all, instead of looking, seeing kind of thing. Third one is by quotations. Normally, we also quote the things. We quote extensively. If you quote 1 or 2 pages, all right, but we can't quote pages and pages, tens and hundreds of pages. So if we do all those things, it will be careless paraphrasing. Even our intention may not be to indulge in plagiarism, but still it is immoral. Then paraphrasing a source without citing it. You take from some internet source, some other source, don't quote anything, but you paraphrase and claim that it is yours. That is also plagiarism. Patchwork plagiarism, poor documentation. Quoting excessively. How much should you quote? You can quote maybe 1 line, 2 lines, 4 lines, 5 lines, but can we quote pages and pages together? Even if we don't intend to plagiarize, it will be violation of copyright and it may amount to plagiarism also. Please remember that everyone has a unique style. Nobody is a born scholar. Even with regard to research works or academic publications, everyone can have one's own style. Like we speak in a different style, we can also write in a different style. And once we have the trademark style, I'll give a small example. When you look at the judgments given by the former Chief Justice, Justice D.Y. Chandrachud, Dr. Justice D.Y. Chandrachud, who retired just a few weeks back, if you see every judgment written by him and published, maybe in a Supreme Court cases, maybe Supreme Court website or whatever, it looks like something unique. He has a particular style. He writes a synopsis also, right? Same thing can be done while writing, in fact, research works, research reports. Otherwise, it will be plagiarism. And I will also give you certain issues of instances of plagiarism. And mind you, even vice chancellors are not spared. In the first instance, one VC of Kumayun University and his colleagues, they are scholars in the field of theatrical. Just a second. Chaitanya. Ante. Madam Pe. Okay. Right. Okay. Then they had to resign. Vice Chancellor had to resign because it was found that they copied from a paper published in Stanford University. Right? Scientist in Physical Review. Similarly, one gentleman called Rangaswamy and, in fact, from a particular group, they misrepresented the data in a paper published in Journal of Biological Chemistry. So normally, this is the most common thing which we should not do. Not only we will be violating copyright violation, but also we will be violating copyright, but also we will be indulging in plagiarism. The data cannot be, in fact, tinkered with. That's what was done. Kavya Vishwanathan wrote a novel. She's a young lady in Harvard. But ultimately it was found that she copied from 2 other adult novels. In Wikipedia, there is a page for her. You can see. And a celebrated, in fact, journalist called Farid Zakaria, he was suspended for some time from New Yorker, because he, in fact, plagiarized a portion of the article. Later on, he was, reinstated. Then, because it so happened that he indulged in self-plagiarism. He copied from his own, but still he copied. The times may be different. Right? This is one. And I will give you another case. Name is there on your screen. I don't want to mention. But here is a lady vice chancellor who was vice chancellor of Central University of Pondicherry. And she allegedly plagiarized a book mentioned in her CV, which was not in existence. Then she also quoted 2 other books, which are not published at all. Then even the single book which was published, 95% of the book was, in fact, taken from some university curriculum, and papers are copied from different authors, including Professor N.R. Madhav Menon, the great, in fact, law professor, right? Founder of NLSUI, right? Then ultimately it was found that there was, in fact, a copying of nearly 24 of 25 research papers. You can see the fate. It can happen to anyone. And there are other instances anyway. I think that there is some problem here. I'll just a second. This. This. Anyway, the point I'm trying to make out is that now we can stop sharing also, but I'll make one last attempt. I think I have 3 or 4 slides. They may not be so important, but still. Okay, fine, no issue. Now, the point I am trying to make out is that as far as the plagiarism is concerned, this is one important aspect which we need to avoid, because in the year 2018, the UGC has come out with certain, in fact, regulations on academic honesty and integrity. And I think we are following that. And the penalties are very severe. And it's not only for the researchers, but also for the research guides. And, in fact, depending on the percentage of similarity, then the punishments vary. And in 2021 or 22, these regulations were amended to include even the self-plagiarism also as one of the important aspects. So this is another important area where I think we need to keep in mind academic honesty is equally important, and we have number of tools as far as plagiarism is concerned. We have any number of tools. Turnitin is the most popular, but article checker, anti-plagiarism tool, there are so many. Point is very simple. It will be very easy to find out from which source a candidate is trying to copy. And we have a multiple colors in our similarity index report. You must have seen that. So it is virtually next to impossible not to be caught unless the authority chooses to look in the other direction. Certainly, in fact, the plagiarism will be caught. This is one important aspect. But when we are talking about the creative works, 2 or 3 important aspects I will try to mention. One is about the instances of something like monkey's selfie. Who can own copyright? Who can, in fact, claim copyright in certain works which are created by animals? There is a famous case called monkey's selfie case. Most of you may be aware of it. In that case, it so happened that David Slater, a British, in fact, natural...
Excuse me, sir.
Pardon?
Sir, the PPT is not visible. Your email...
Yeah, I stopped sharing, ma'am. I stopped sharing. Now, in fact, you can only look at the screen. The PPT I will share. Maybe I don't know if it is available with Dr. Jayanta. For some reason, the last 3-4 slides are not seen, but I am giving the gist of it. I remember all this. And I'll send it. I'll send it across. It was there in the PPT in the morning. I don't know, somewhere because of some technical snack, I think it's not displayed. Coming back to monkey selfie. Just imagine a situation. David Slater was working on certain black chimpanzees in Indonesia. They are the extinct species. And he befriended them, became friendly with those chimpanzees. Then he noticed that those chimpanzees were observing very carefully the way he was using his camera to take photos. So he was, deliberately training them directly or indirectly. And one day, deliberately, he kept the camera there. It was switched on and he went away. Then one of the monkeys came up and switched on the camera, shot a selfie. So 2 or 3 wonderful selfies were, shot by the chimpanzees. When he came back, he was very happy. He sold those selfies to one of the international magazines, made good amount of money, right? He claimed that he was the copyright owner. But the real twist came when PETA means People for Ethical Treatment, of Animals. This is a voluntary organization at the international level. They filed a case in one of the circuit courts in USA, stating that he is not the owner of copyright. Monkey is the owner of copyright in the selfie because monkey took the selfie. Now, whatever amount he has earned by selling the photos, that must be used only for the welfare of the monkeys. That was the argument. And that is how it comes. Slater versus Naruto. Naruto versus Slater. Slater is David Slater. Naruto was, the monkey. On behalf of that, PETA, impleaded. And the Supreme Court of USA, not Supreme Court, the Circuit Court of USA, after going through all the jurisprudence, ultimately ruled that only a human being can be the owner of copyright. Without human intervention, no copyrighted work can be produced. No doubt, he must have trained the monkey, and monkeys must have learnt a lot from the way he was operating or handling the camera. But it doesn't mean that monkey can claim any copyright. So that is one important aspect. And this is not some new jurisprudence. It has been there from the time immemorial that animals are not capable of rights on their own because they are claiming through the human beings. So it is a human-centric approach. This is one important aspect. And similarly, there was a very interesting case of Picasso. Picasso, Pigcaso, Picasso. If you are in front of a system, you can simply type Picasso paintings. You will come across number of paintings. Pig painting. Look at this. The pig painting with different colors, different strokes. And you have number of paintings. And you will find some of the paintings used by even Swiss Airlines. Swiss Airlines also purchased some of the paintings of Picasso from a lady who was the caretaker of Picasso. The story is like this. She rescued a small piglet. She was an animal lover. She rescued a small piglet. Somehow she noticed that it is very much interested in painting. Then it provided a brush, provided the colors, provided the screen. The net result was something fantastic. The pig goes on, in fact, painting, eating and painting, nothing else. Question is, who will have copyright in the paintings? Painting is a literary work. It is a creative work. And she was not trained to paint. It was painting on its own. There was no case, but the fact remains that whatever was the law laid down or principle laid down in David Slater's case, the British nature like photographer, applies equally to this. Now I'll come to the third case. This is important. We are all using artificial intelligence, AI, machine learning. And sometimes I also make use of it. If I don't have sufficient time to look at the latest case law, in WhatsApp, I'll simply, I'll type latest cases on so-and-so topic. And more often, I'll get, the list of such cases. Now the question is, if there is a write-up given by AI tool, artificial intelligence tool, right? Whether it is, whether Alexa, Siri, ChatGPT, or, that is from OpenAI and all. Question is, who can claim copyright in such AI-generated works, artificial intelligence-generated works? Now, Lot of debate is going on, not with regard to copyright, but with regard to patents. There is a series of cases called DABUS cases, D-A-B-U-S, DABUS, D-A-B-U-S, DABUS cases. So these DABUS cases are filed in different jurisdictions. Initially, they were filed in England, then European Union, then USA, then Australia, then South Africa, Germany also. And except in South Africa, the cases were filed by somebody called Stephen Thaler. And Stephen Thaler invented certain, new products. And he claimed copyright for this particular AI entity called DABUS. But except in South Africa, in all the other countries, the courts rejected his claim that DABUS is the inventor. They said, you are the inventor. Because of your assistance, your guidance, your prompting, the AI created such inventions. Only in South Africa, it was otherwise. Same thing can be said in the case of AI generated works. AI generated copyrightable works. Morning, I was going through some article. You all watch Animal Planet or National Geographic. You will come across certain photographs, certain images, certain video clippings, which are through trap cameras, TRAP, trap cameras. Those trap cameras are kept in dense forests at some secret places and hoping that, the moment an animal passes through, a snake passes through, something significant happens, immediately it is captured. Now the question is, who will claim copyright in that? There is no training there, right? But as of now, still human beings are claiming copyright, and the courts are also coming to the help of only human beings. Things may be different. In India, there is a classic case of Raghav. Raghav is a painting. That painting is by one particular gentleman, Ankit Sani or somebody. Then he claimed that himself and artificial intelligence tool, both of them are co-authors of that painting. Very interestingly, Indian Copyright Office registered the, in fact, ownership of copyright in respect of that AI painting called Raghav, R-A-G-H-A-V. Later on, there was a lot of criticism saying that all over the world, even the AI is not treated as an entity. AI can be at the most only a tool. It can't be the owner of copyright, right? But some kind of notice was issued, nothing happened. But in future, certainly the question will be about the AI created works. The question will be about the ownership of copyright in such works, because human intervention may be limited in certain cases, right? Hand holding by the human being is something. Then, in fact, creating a program which works on its own is something else. I gave few examples also. And with last one observation, one reference, I will close. There was a very interesting case as far as our academicians are concerned on course packs. You call it the Rameshwari photocopying works case, 2016 Delhi High Court, where Delhi School of Economics professors finalized a very ambitious syllabus in one of the papers in their PG course. Unfortunately, there was no single book in which the study material was available. Therefore, the professors suggested to go through different books for different topics of the same paper. Then, so somebody copied maybe chapter 1 from one publication like Taylor and Francis, and maybe one more chapter from Clover International, another publication, one more chapter from Oxford University Press, one more chapter from Cambridge University Press. Ultimately, all of them were collated. All of them were collated, collected, and when the Xerox fellow who was running the shop in Delhi University, Rameshwari photocopying works fellow, came to know that there is a lot of demand for such collection of articles, he neatly arranged them. Then he started giving course packs. Course packs. Funny thing was that from none of those publishers or authors, permission was taken. No permission was taken. No royalty was paid. No assignment was made. No license was taken. Then the students went on using it after photocopying it. 5 paise concession was given per page by the Rameshwari photocopying Xerox owner. Then this was considered as infringement of copyright. They took the matter to Delhi High Court. I'm talking about Oxford University and other universities. And their argument is that our copyright is violated. It is infringement of copyright. But Justice Rajiv N. Law of Delhi High Court, after a lot of consideration, held that it is for instructional purposes, it is for educational purposes, therefore it amounts to fair use. It amounts to fair use, right? And there is no violation of copyright. In fact, many of the publishers wanted to go for appeal also. Somehow they have withdrawn. Today, the course packs are not violation of copyright. I personally have my own, in fact, reservations on this particular judgment of Delhi High Court. But nonetheless, we have, in fact, maybe a larger public interest served in allowing course packs to be produced without license or assignment from the concerned copyright owner. So this is another development. And Sci-Hub case also is one of them. Sci-Hub. So Alexandra Elbankia, she's the lady from one of those, Russian Federation countries. And she made the downloading of even proprietary articles available without paying a single pi by using certain technology. Otherwise, the users were required to pay huge amounts of money. She was sued in United States. She didn't enter defense. She was set ex parte. They said it is illegal. Then they changed. LibGen became Sci-Hub. Sci-Hub is available in India also. A case is pending before the Delhi High Court. Maybe I think you can keep track of that particular development. Whatever, these are some of the latest developments. But we need to understand the ethos of copyright. AI ethics are equally important. Then, in fact, we must know where the Lakshman Rekha has to be drawn between the fair use and infringement. And we need to avoid plagiarism, because ultimately the real scholarship is only by originality, not by plagiarism. I'll stop here. I think you have 7 minutes for interaction. Now over to the organizers. If you have any questions, maybe, depending on your procedure, you can raise them. Over to you.
Thank you, sir. Krishna, are you available?
Yeah, you are.
No, Krishna? Okay, so participants, we can take 1 or 2 questions since we are already short of time. Any questions? Anyone would like to take and unmute themselves?
Jai Santoshima. I think she has raised her voice. Raised hand. Thank you.
Anyone who want to put any question?
May I, sir?
Yeah.
Yes. Good afternoon, sir. Sir, can you throw some light on Anil Kapoor's Jackass dialogue case, sir?
Oh, yeah, I made a passing reference. And in fact, this is the result of 2012 amendment. Anil Kapoor pronounces that particular dialogue, Sakas, in a particular style. Same is the case of Jackie Shroff, pronouncing Bidu. Or so ultimately, we are trying to integrate the personality rights of the celebrities as part of the performers' rights and also moral rights, both of them. And in Delhi, I think both of them succeeded. Anil Kapoor as well as Jackie Shroff. I think because some kind of uniqueness has been brought about by the way the dialogue is, pronounced. If at all anyone has to object, it must be only the director of the movie. That's all. Except that, I think no one else could do that. Maybe director also considered that it is their own style, which could be owned by them or monopolized by them, and that's what is going on. So performance rights, celebrity rights, personality rights, because one's own person is one's property. The Hegelian theory of property.
Thank you, sir.
Hello.
Yes,
Hello,
sir. You
sir.
can ask. Yes, sir.
Hello.
Yes, please.
What are the famous case laws
Well,
on copyright exclusively in India, sir?
Start from R.G. Anand versus Deluxe Film.
Yeah.
R.G. Anand versus Deluxe Film to latest, in fact, this Chancellor and Masters of Oxford University versus Rameshwari photocopying works. You have any number of cases, sir, hundreds of cases.
Famous case laws.
Including those on the copyrightability of computer software also.
Yeah, one simple is there, na, sir. Ranganayakama versus Dasa Narayan Rao, Gorintaku film, AP High Court 1980.
That's ultimately confined only to the Telugu speaking states.
Yes.
So we are going beyond that. But anyway, that is also an important one.
Important case law. And RK films.
There are so many, sir. Not one.
Sir, Prabhakar sir, do you have any questions?
Yes. No questions. That is
yes, sir. Thank you, sir.
Thank you.
Any participant?
Am I allowed to ask a question?
Ramya madam, please ask.
So very good evening, sir. So this is the second time I'm hearing your lecture. I'm so excited, and I'm really thankful to you for the insights that you have given, sir. My one question is about when these online lectures are given, when it is being recorded, and subsequent to which when it is getting published in the online, what kind of copyright protection that it is available, sir?
I'm sorry, you have to repeat it a little louder. Please.
So 1 minute. Am I audible now?
Yeah, you are audible. You are audible. Yeah.
Sir, when there are online lectures given like this and it is getting recorded and subsequent to which it is being published in the YouTube channels, how for the copyright protection that it is available?
Honestly speaking, it depends on the agreement between the person who is delivering the lecture, the organizer, and depending on the terms and conditions between them. Normally, before recording, permission needs to be taken from the speaker. Thereafter, all these details can be specified. Because if it is going to be commercialized, then without the knowledge or without the consent of the original author or the performer, then it will be violation of his performer's right.
Okay, sir.
Everything needs to be at least in the offer letter and maybe offer acceptance, some kind of licensing agreement, etc. Every time, because it happens in the case of these FIAM and MOOCs courses, there is a proper assignment, pro forma, and in FDP programs like this, I don't think it's really followed. Everything is done in good faith.
Okay, sir. Thank you, sir. Thank you so much.
Dr. Damayanti, ma'am, you can unmute yourself and ask the question. Dr. Damayanti, ma'am. Okay, Ramani, madam.
Now Damayanti madam came. Both the madams have come, and then Damayanti madam again muted herself. Yes, Dr. Damayanti ma'am, you can ask. I think Dr. Ramani will follow. Yeah.
I think. I think, sir, it is by mistake, I guess.
Okay, fine. I think Dr.
I think there is a comment by Vipasa Saika ma'am just check in the share box.
Yes, sir. Yes, sir. Sir, there is a question. How do we reconcile between maintaining the personality rights of a celebrity deceased and rights of filmmakers' creativity? Can they simply get away by stating that the information available is in the public domain without verifying its authenticity? This is with reference to this Sushant Singh Rajput's case.
Honestly speaking, this area is slowly gaining momentum in our country. Previously, we never thought about it. And ultimately, everything depends on the kind of consensus between the parties, the agreement, assignment, terms and conditions of the assignment. Just because the performance is going to be in the public domain, it doesn't mean that, because it is a creative work. In respect of creative works, certainly the creator will have a greater stake. The author or the performer will have a greater stake. And only that much portion of his rights or her rights, which can be used by others, probably can be, in the public domain or as part of the agreement. But it doesn't mean that the right to privacy cannot be insisted upon by public personalities. So there is a Lakshman Rekha even for that. K.S. Puttaswamy judgment has thrown enough light. Right.
So there is one more question. Ramani Garmella ma'am. Vedic education and traditional education and its scope in this subject. Please, she wants to know your thoughts on this.
Ultimately, as far as Vedas and other forms of traditional knowledge are concerned, it is part of the Indian knowledge systems, if we can put so. And that is the original source. You take it as an idea, but that idea can always be expressed in any manner we like. We can add something, we can, explore or explain in a different manner. The relevance still continues even for ages to come. And because I personally feel that many of the things which we are using or saying, they can be traced to the Vedic times. So therefore, but only thing is, there is no copyright in Vedas. But if you are trying to interpret Vedas in a particular, in fact, style or manner, or in the form of a sermon or a series of sermons, again, you will have the copyright in them. No doubt, Vedas are not copyrightable today because they are in the public domain. And probably at the most, we can identify somebody as the author. If at all, we can, recognize or identify. Probably that's not possible also. But we have to give our human touch in order to bring it within the purview of the author or the creator. That can be done. Relevance will continue forever.
Thank you, sir.
Krishna, I think that's enough. We can take the questions later on through other communications.
Okay, sir. Sir, now I request Miss Ragini, my colleague friend, to propose vote of thanks.
On the behalf of Department of Law, Central University of Karnataka, I extend a warm thanks to Sir for delivering a wonderful, insightful lecture. I hope the participants got an extensive explanation on this subject. Thank you so much, sir, for taking out your time and delivering this lecture. Thank you, sir. Thank you, dear participants, as well, for staying so long on this session. Thank you so much.
Thank you all. Thank you so much.
Sir, thank you, sir.
Thank you, sir.
Thank you, sir.